Yes, hi. Good afternoon, everyone, if you're on the East Coast. Good morning if you're on the West Coast. And good evening if you happen to be in Europe or in Asia. Welcome to the March 2021 TSCA 30. So, by the way, you may have noticed that we have a new slide deck, and we actually have a new logo for Keller and Heckman, and which is in the right-hand corner, upper right-hand corner of our slides. So you wouldn't imagine how long it took people to come up and how many different consultants we had to come up with a new logo. But that's the new logo. I hope people will like it. Check out our new website. It's quite a nice one. And it's still the same place, www.khlaw.com. Anyway, today's topic is forever chemicals. And so we're going to explain what that means. Next slide, please. Next slide, please. Yes, hi. So I'm Herb Estreicher. I've given many of these. That's my bio, and I will let you read that at your leisure. As always, we will be posting the slides, audio recording of the session. Next slide, please. Today, I'm joined by two of my partners. So this is really one of the unusual occasions where we have a number of us that are presenting. Sometimes we have one person present, most often two, but today we have three. Eric Gotting is a partner in our environmental group who specializes in environmental litigation. So remember his name, Eric Gotting. Next. James Votaw is also my partner, and he's presented on a number of these. And his bio is there, and you can review that at your leisure. So what are we going to talk about today? Well, we're going to talk about the fluorinated chemicals, PFAS. We're going to talk about regulation of PFAS. We're going to talk about some of the litigation that's ongoing with respect to PFAS substances. And we thought we'd mix it up a little bit. Since we're talking about PFAS, we'd also talk about PBTs, persistent bioaccumulative toxic chemicals, primarily because there's been some developments in terms of TSCA ban rules that have issued under Section 6, and we wanted to make sure that you were aware of those. So there's a lot of regulation of PFAS chemicals that are ongoing in the U.S., although quite frankly, it pales in comparison to what's going on in Europe. And actually, if you're interested in what's going on in Europe with respect to PFAS, then I would suggest that you attend our Reach 3030, which will be at 1:35 p.m. Eastern time, where we will tell you, where Europe is with respect to PFAS chemicals. Now, I think when you listen to my presentation, you'll realize that the U.S. is very far behind Europe in terms of the aggressiveness which they're trying to deal with PFAS chemicals. Although there is still a lot going on in the U.S., you have to recognize that the PFAS problem largely arose, or at least the recognition of the PFAS problem, with the exception of the two very famous PFASs, which are PFOA and PFAS. But for the category as a whole, the problem really arose during the Trump administration. So quite frankly, you would not expect very much to be going on. But now that we have a Biden administration, things are going to ramp up very quickly. And I want to tell you, there are some relatively few cases where there have been, umbrella regulations on whole classes of chemicals. I mean, the ones that come to mind are dioxins, PCBs, and fluorocarbons. So it's been relatively rare that you see a kind of feeding frenzy against a whole class of chemicals. Now, let's talk about dioxins. Well, dioxins are really the only really recognized and acknowledged documented bad actor is the 2378 TCDD. And yet the entire class of chemicals have been implicated and effectively banned. And so we're starting to see the same thing with PFAS, where there is some recognized problems associated with two of the members, PFOA and PFAS. But the question is, there's a large number of these chemicals, and there seems to be a move afoot to regulate them, as a class. So what's been happening with respect to PFAS in the U.S.? Well, first, it is a fair number of these are covered under the Toxic Release Inventory Reporting Rule. And if you import, manufacture, or process PFAS chemicals, then you're probably well aware of that. Because your first reporting was last year. Also, EPA under TSCA has issued a significant new use rule, or SNUR, to deal with the import of products that contain PFAS in the surface coating of the products. Why is it limited to import? Why is SNUR? Because the domestic use of these regulated PFAS compounds have long been prohibited to make things like furniture, automobile parts, et cetera. And so EPA issued a SNUR to make sure that if someone tries to import products that have these substances in the coating, that they would be subject to prior notification and approval by EPA. So a significant use rule, and that's the most detailed thing that occurred under TSCA for PFAS so far. Now, there are some 600 PFAS substances. As I pointed out, the data demonstrating that they're of concern really only applies, the data set really only applies to 2 of them. However, using read-across principles and things of that nature, it's kind of believed that, well, there may be issues associated with the rest of these. Why that's the current thinking, at least in some quarters. So of the 600 PFAS chemicals, they're on the active TSCA inventory. EPA has actually reviewed 60% of those under the Section 5 New Chemicals Program. And since 2006, EPA has reviewed around 300 PFAS chemicals on the new chemical program, and has issued consent orders or SNURs for some 200 of them. So by and large, there is some regulation in place in the US for a large number of the PFAS chemicals under the TSCA New Chemicals Program. There has been a toxicity assessment for PFBS, which is one of the PFAS substances. I think you probably read about that in the press. And that was issued in the final days of the Trump administration, and that assessment has been heavily criticized as having been compromised by, quote, political interference. And so that assessment is basically going to be withdrawn. Next slide, please. Environmental groups are very active when it comes to PFAS. EPA has received a petition under Section 21 of TSCA from 6 advocacy groups, and what they want is EPA to order a study of the health and environmental effects of some 54 PFAS substances that the petitioners say are linked to a particular facility in North Carolina. So they ask EPA to use their authority under TSCA Section 4 to order the company that owns the facility to fund testing under the direction of a panel of independent scientists. And as Eric Gonning will tell you, there's a lot of litigation involving PFAS chemicals, and in some of these cases, the relief that plaintiffs are asking for is exactly the relief that these petitioners are asking for in this Section 21 petition. What they would like is they would like industry to fund testing under the direction of a panel of, quote, independent scientists, end quote, that are selected by the NGOs. And what they plan to do is they're hoping that these, quote, independent, end quote, scientists will conclude that these PFAS chemicals are of concern and cause, certain adverse effects, and therefore they can then show causation in these lawsuits and go right to damages. And so that's the intent of this petition, and that's also the intent of a lot of litigation that's going on right now. EPA denied the petition, which is fairly common during the Trump administration, but I question whether that'll be the case during the Biden administration, whether EPA will deny Section 21 petitions. Recall there's been a fair amount of litigation involving EPA's denial of Section 21 petitions with respect to fluorinated chemicals in fluorine in drinking water and asbestos reporting on the CDR. The environmental groups have made fair inroads in connection with Section 21 petitions and litigating the denial in court, and I suspect that that may cause the Biden administration to deny fewer of these petitions than was done under the Trump administration. Why did EPA deny the petition? Well, they say that the data is not needed. Well, there you go. Next slide, please. Not only is EPA involved, but California, which a lot of people consider to be a separate country, is very active with respect to PFAS regulation. California's Department of Toxic Substance Control, which is their version of EPA, they plan to regulate PFAS as a class under their Safer Consumer Products program. They say, why regulate PFAS as a class? They say because the individual PFAS never occur in isolation. They can't be effectively regulated in isolation. Okay, and they say taking a class approach encourages innovation, developing safer alternatives, and reducing the risk of regrettable substitution. Well, I think you could say that about any chemicals. But in any event, they plan to try to regulate them as an entire class under the Safer Consumer Products Program. And so apparently California is near completion of a priority product designation for carpets and rugs containing the substances. And they're also working on proposals for PFAS containing textile treatments and food packaging. Now, of course, PFAS and food packaging would not be under TSCA, but it does fall under the California jurisdiction under the Safer Consumer Products SCP program. Next slide, please. There's at least 18 other U.S. states other than California that are taking under advisement restrictions to use PFAS in various products. Most of the focus is on food packaging and firefighting foam. And Eric will talk about some of the litigation involving the use of PFAS in firefighting foam. Canada, which a lot of people consider our 51st state, is also announced that it's looking at ways to broaden its class approach to PFASs, but unlike the European Union, it has no plans to adopt a restriction on the entire class, but will be more targeted. Next slide, please. Industry reaction. Well, okay, so McDonald's, for example, has committed to globally phasing out the use of PFAS from its consumer packaging by 2025. And you may know that PFASs are widely used in food packaging, containers, cookware, and consumer products. And they have a grease-proofing, waterproofing, non-stick quality that they impart to these products, which is why they're widely used. But anyway, McDonald's commitment to globally phase out the use of PFAS is actually part of a growing effort by a growing list of retailers, including Panera Bread, Taco Bell, Whole Foods, Trader Joe's, Albertsons, Sweetgreen, and others. And so this is pretty much following the usual trend in the US. So what I try to explain to European audiences, which I will explain at 1:35 if you're interested in our Reach 3030, is that Europe regulates, bans everything, very little enforcement. In the US, very little regulation. However, litigation takes the place of regulation in many, many respects, as does product stigma. And environmental groups work very hard to ensure that corporations that deal with consumers, the McDonald's of the world, the Taco Bell of the world, et cetera, Amazon, Apple, et cetera, that they make commitments to basically do their own banning. And that's really how things get banned in the US. They don't get banned by and large by regulation. They get banned by as a consequence of litigation risk and as a consequence of reactions from customers. Next slide, please. Another development, and then I think hopefully the last development I'm going to talk about, is that PFAS chemicals have been found in pesticide containers. And this is kind of a new development. And it's been found so far in the container of a particular pesticide, which is an adulticide used to control mosquitoes. This problem was identified by an environmental group in Massachusetts. They first notified Massachusetts state agencies. EPA Region 1 got involved, very, very quickly. They asked for samples, and it was determined that the source of contamination was the use of fluorinated HDPE containers. Mentioned that PFAS is used in food packaging, but this is the first time it was recognized that PFAS was used in other kinds of consumer packaging, and in particular, packaging that's used in connection with pesticides. So EPA is asking other pesticide companies that fluorinate containers to engage in good product stewardship, to examine their distribution chains to cover potential areas for contamination. Next slide, please. I'm going to turn this over to Eric Goding, who's going to talk about PFAS litigation and the activities there, and hopefully he'll tell us about that movie that was very popular for a while. I can't remember the name. Eric?
Yes. Well, thank you for joining us today. Many of you are probably aware that there's extensive ongoing litigation regarding PFAS contamination around the country. Many of those cases, at least those involving firefighting foams, have been consolidated before a federal court in South Carolina, but there are also many individual cases in state and federal courts as well that don't involve firefighting foams. And while many of those lawsuits have been filed against the major upstream manufacturers of PFAS materials like 3M and DuPont, we are seeing lawsuits filed against downstream users of PFAS materials where it is possible to trace that, any contamination problem or exposure problem back to a particular facility or product type. So I just wanted to summarize what plaintiffs' lawyers and governmental enforcement agencies are looking at when bringing these lawsuits and what can potentially lead to extensive liability. So first, there are many different types of PFAS exposures and forms of contamination that have been alleged. Processed wastewater is an issue, whether it has been discharged directly into adjacent water bodies, deposited onto nearby land, or more likely sent to a local POTW. And these discharges can ultimately contaminate public and private drinking water sources, as well as nearby residential and commercial properties. Air emissions are another potential source. Nearby residents can be exposed to contaminated airborne particles. PFAS emissions can be deposited on soils, and this can also lead to drinking water and groundwater contamination as rain drives the PFAS below the groundwater surface. And in fact, that was a major issue in the Washington Works case, which was the subject of the movie that Herb just mentioned. Yet another issue is landfilling. This can be in the form of processed sludges or contaminated waste, such as drums that contaminated PFAS and other used equipment. And so some lawsuits involve allegations that the landfill PFAS has migrated off-site and contaminated soils and nearby surface waters and groundwaters. And there have also been some worker exposure cases where employees are exposed to raw PFAS materials during the manufacturing process. And then finally, we have product liability cases where there have been exposures from commercial products, the most prominent being firefighting foams and equipment. So it is important for all manufacturers and downstream users of PFAS to take a hard look, not only how they handled and disposed of PFAS materials in the past, but also what their, how they do that now, but also how their legacy practices handled these materials, 5, 10, 20 or more years ago. And this holds true, and this is a really important point. Even where you only use or used very small amounts of PFAS at any given time, given that PFAS compounds do not easily break down in the environment and biopersist, substantial contamination can result from very small releases or emissions over long periods of time. So next slide. So second, we're seeing all kinds of litigation resulting or ranging from single plaintiff cases, cases brought by municipalities and state governments, mass tort cases where you have a bunch of cases that are consolidated before one court, and class actions. And these lawsuits allege all sorts of causes of action and types of damages. We are seeing personal injury and wrongful death claims, including cancer, and demands for ongoing medical monitoring throughout entire communities. We are seeing property damage claims and demands for extensive soil and groundwater remediation. We're seeing public and private water suppliers and POTWs filing suits and requesting extensive testing. They're demanding retrofits with new filtration equipment like carbon filtration and requesting that contaminated equipment like pipes be replaced. We are seeing product liability claims, again, like the AFFF litigation. And of course, there are government enforcement actions, including under Superfund, hazardous waste laws, natural resource damage statutes, and the Safe Drinking Water Act. And so lastly, to bring this back to the regulatory world, one thing to watch are efforts by states to continuously lower the regulatory cleanup and exposure levels for various PFAS substances, whether in groundwater, drinking water, or soil. And the reason why these are important is because not only do they drive enforcement actions, but the plaintiff's lawyers will also cite to them as the level at which a defendant should be found liable. In other words, these are the regulatory levels that set the standard of care that they will argue manufacturers should have been operating under. So pay close attention to the litigation as plaintiffs' lawyers and governments start to move away from the raw PFAS material manufacturers and start to focus on downstream users of PFAS materials in certain facilities. So with that, I'll turn it over to James.
Yeah. Just before we switch topics, one of the participants sent a note saying the movie was called Dark Waters.
Yes.
And actually, I looked it up and it has a Rotten Tomatoes score of 89% favorable by critics and 95% favorable by the audience. I turn it over to James. James?
Okay. All right. Thank you, and Eric. So we amended our program here to squeeze in a little information on some developments on the TSCA PBT rules, just because of some recent developments. So we're going to shift gears here a little bit. As many of you may know, EPA was directed by the Lautenberg amendments to regulate TSCA work plan chemicals that met certain criteria to be classified as PBTs, persistent bioaccumulative and toxic. They're required to issue those rules by December of 2020. This is different from the other kinds of risk evaluation or risk management rules that EPA is working on, in that EPA was not required to do a risk assessment. They were required instead to set standards that would reduce exposure to the PBTs, to the extent practicable. So sort of going beyond risk. And so EPA started this process in 2016. They proposed rule in 2019, and the final rules that were published actually in January 2021. And those, I won't go through the details of those. We've got it on the next slide here. You can go back and look later if you're interested. But essentially, EPA's approach was to essentially ban sort of the ongoing uses of each of the 5 PBTs that they identified as being subject to the requirement here, with certain exclusions for where it would be impracticable to reduce exposure any further. These rules, so they were published just before the turnover administration. Biden EPA as part of the review of all sort of unpublished or not yet effective rules, took a look at these and decided on February 5th to let them go into effect, but with a note that they would be subject to further review in the future to make sure that they are sort of consistent, I think, with governance policies of the new administration. There over, and I would say some criticisms of these rules as they were promulgated, or as they were proposed, were EPA's election, not to directly regulate occupational exposures, not to regulate disposal, and not to regulate ongoing use of products that may contain some of these things, largely fire retardants. They're already in commerce, but could be potential sources of exposure. Also criticisms of EPA's approach to some of the exclusions, that they were time limited and didn't follow some of the limitations under one part of the statute for setting exemptions for products for chemicals that go through the full risk evaluation process. And then from the industry side, there was these rules regulated not just the raw chemicals, but also articles that might contain them. And there's complaints that EPA should not have regulated articles without doing a risk assessment to show that there were exposure or relevant risks associated with the use of the chemicals in articles. So I said we can skip that. And those were quietly promulgated. Didn't seem to be a lot of controversy, except with respect to one, which is with PIP. And we started, I think, starting to hear awareness from a lot of companies, sort of becoming aware for the first time that in December of 2020 that they may have PIP in their supply chain. And we're investigating that, but we're surprised to find that they may have PIP in some aspects of their supply chain, and not having, there's very short transition time to March 9th is the effective date for bans on products, articles that may contain PIP, perhaps in a component. But there was a ban on distribution or manufacturing those here in the United States, and really caught companies short. And it's hard to explain why that was the case. I mean, these rules were obviously sort of in process with very public processes for a number of years. But in any event, it caught a number of companies, at least certainly end use and producers of articles, caught short with possible supply problems. And so there were sort of emergency appeals to EPA to extend the timeline, ahead of the March 9 effective date, when products with PIP would have been, part of articles in the channels of trade would have been sort of stranded, could only be sort of disposed, and otherwise supply chains for new products would be in jeopardy. So EPA, to its credit, I think realized that, right or wrong, that the companies were not prepared to make this transition, and they found a way to provide some practical relief to sort of extend the time to make this transition. And so working with the Office of Enforcement and Compliance Assurance, so WECA, EPA's enforcement arm, issued a no action assurance letter for PIP, for the PIP rule, at least in a limited way, and it would allow companies to continue to distribute and process articles that contain PIP and PIP that would be used to make articles for 180 days until September 4th, with the view that EPA would be taking action in that period to extend as appropriate the deadlines for making this transition to get the PIP out of products and out of supply chain. So it provides for an orderly transition for companies who were caught short. It doesn't apply to anything, so there are a number of to the extent that the PIP is not used in articles, are going to be made an article containing PIP or used to make an article containing PIP. The current restrictions or exclusions continue to apply. Bans on releases to waters. There's some ongoing sort of record keeping and downstream notification obligations that will continue to apply. These are sort of specified in the no action assurance letter. I think sort of equally significant is that EPA also sort of took the opportunity to go back now and to sort of reopen all 5 of the PBT rules. And they're going to look at, this question of, what are sort of the appropriate, practicable transition periods companies need, again, to make substitutions and to clear the channels of trade. But they're also taking comment on all aspects of the rule. And this sort of provides the opportunity for the agency under the Biden administration to, go back to the basics of the way that the Trump team had interpreted the statute and designed these rules. So, going back to revisit questions about whether disposal and occupational exposure ought to be directly regulated, whether the current exclusions were sufficiently narrow and done under the proper authorities, and additional considerations that come with the Biden administration or the new executive orders, thinking about environmental justice and the integrity of the science. So really, there's really has sort of opened the door, both I think for practicable transition, but also perhaps to increase the sort of scope of these current PBT rules, at least as it relates to these chemicals. So I would just say in closing, as a practical matter for those companies who've got PIP in their supply chains, and even if you've got an exclusion for the first round of rulemaking, or you need a deadline, that it's really critical not to rely on some generalizations about what may be involved in making substitutions or whether that's possible or practical. The agency really needs facts, substantial evidence to base these decisions on. You should not rely, I think, on sort of general statements about what is or isn't difficult to do. So with that, that brings us really to the end of our period. As Herb mentioned,
Yeah.
we have, you've got.
Yeah. So anyway, if you're interested in hearing about what's going on with PFAS chemicals in Europe, join us in about 5 minutes. And the next TSCA 3030 will be on April 7th. And there's an OSHA 3030 on March 24th. Last slide, please.
Yeah.
So that's tells you a little bit about that. Is there a conclusion slide that shows our pictures?
No,
No.
there's not. But I would just
Okay.
say that if you try to go to the Reach 3030, you need to log in through the link that we're provided. If you don't have that, you can just search for our Reach 3030 page, and you can sign up and get a link sent to you right away.
Very good. Anyway, thank you for all for joining us, and for those who stay on for the Reach 3030, I promise that it'll be informative. Bye.